talk to you all about the relationship between the Perry case and the DOMA Challenges and some other federal court litigation that's kind of relating to family recognition with an eye to figuring out, well, how does all this sort of mesh together right now, and in particular, like, which one of these cases is likely to get to the U.S. Supreme Court first, and, you know, what's it all mean? So I thought, you know, we should talk about Perry first. And, you know, Judge Walker issued his great decision striking down Prop 8 last August, and then that decision was appealed to the Ninth Circuit, and they put the case on an expedited track. You know, the plaintiff said, hey, don't stay it, you should let Judge Walker's decision go into effect, and the Ninth Circuit really kind of ducked the merits, the legal merits of that state petition, and just said, well, we're not gonna rule on that, we're not gonna uplift the stay, but we're gonna put this on a fast track. So they did. Now, as everyone now is like well aware, in addition to the kind of core constitutional questions presented by that case, which are the huge giant questions about do gay people have a right to marry, and what level of scrutiny should apply to laws that discriminate against gay people, and these central constitutional questions for our community, there are these questions about standing and about whether the proponents have standing to appeal the case. And I know that people probably know, you know, you kind of know all this now, but there's a little bit of the backstory that I think at least many people are not aware of, that I thought it would be interesting to share with you all. So the leading Supreme Court, U.S. Supreme Court decision on this issue of standing and whether ballot initiative proponents usually have standing is a case called Arizonans for Official English. A state employee of Arizona brought a case challenging an Arizona ballot amendment that had adopted English as the official language of Arizona. So that employee won. The state did not defend the measure, and the state did not appeal. So very similar to the situation we have now with the Prop 8 challenge. Then the Ninth Circuit allowed the initiative sponsors to intervene on appeal when the case went up to the Ninth Circuit. And they said, okay, yeah, initiative sponsors, you can come in and appeal the trial court decision. And they ended up affirming the trial court decision, and then that went up to the U.S. Supreme Court. And the U.S. Supreme Court reversed the Ninth Circuit, and they said, nope, you guys, you were wrong to say that ballot initiative proponents have standing. They don't have standing, and if you had any questions about that Ninth Circuit panel, you should have certified that question to the Arizona Supreme Court. But I wanted to share with you, too, about what the U.S. Supreme Court actually said about that issue, about initiative proponents, where they have standing. Is that petitioners argue that as initiative proponents, they have a quasi-legislative interest in defending the constitutionality of the measure they successfully sponsored. They stress the funds and the effort they expended to achieve adoption of the amendment. We have recognized that state legislators have standing to contest the decision holding a state statute unconstitutional if state law authorizes legislators to represent the state's interests. These proponents, however, are not elected representatives, and we are aware of no Arizona law appointing initiative sponsors as agents of the people of Arizona to defend, in lieu of public officials, the constitutionality of initiatives made law in the state. Nor has this court ever identified initiative proponents as Article III qualified defenders of the measures they advocated. So you get the idea about how very similar the issues were in that case to what's being argued in the Prop 8 case, with the proponents saying, hey, we sponsored this law, we spent all our time and money to get this thing passed, surely we have standing to defend it. But really, if you look at this Arizonans case and the analysis the court put forward there, it sure doesn't look like they do. But just to, you know, thicken the plot a little bit, two of the judges who were on the Ninth Circuit panel that decided the Arizonans for Official English case, and they got reversed by the U.S. Supreme Court on this very question of standing, were Judge Reinhardt and Judge Hawkins, who are also now on the Prop 8 panel. So you can maybe see a little bit more, given that they had gotten reproved by the U.S. Supreme Court and said, no, your analysis was wrong, and hey, if you had any question, you should have certified that to the Arizona Supreme Court. It's not that surprising that this panel, with the same two judges involved in the prior decision where they got kind of yelled at by the court for not certified the question to the California Supreme Court. So that's a little bit more about how that all came to pass. But what's frustrating to many of us, and myself included, about that turn of events is there suggest that California gives ballot initiative proponents some kind of special power to override the decisions of the elected state representatives, the Attorney General and the Governor, who have the authority to decide whether to appeal a case. So it's really frustrating that now we have to wait months and months for the California Supreme Court to rule on this issue. And the California Supreme Court did agree. They said, yes, we will take this question, we'll accept this question. They didn't have to, and but they said that they would, and they set a briefing schedule that has a target date of them holding oral argument in September, which means we're likely not going to have a final decision from the California Supreme Court until November, December, even January of next year. And then the case still has to go back to the Ninth Circuit, and then based on whatever the California Supreme Court says, they'll decide whether the proponents have standing or not. And if the Ninth Circuit decides they do have standing, then they'll go ahead and decide whether Prop 8 is constitutional. And if they strike it down, that decision will quite likely be appealed to the U.S. Supreme Court. But so that could be happening around, maybe 2013. And if the Ninth Circuit decides they don't have standing, then the proponents, I'm sure, will try to appeal that decision. It's probably less likely that the U.S. Supreme Court would take that up. They might not. But if they don't, then that will be the end of it, and it'll be the end of Prop 8. But again, that could happen, the soonest it seems like that could happen is maybe sometime in 2012, or again, maybe 2013. So we're still a ways away for the resolution of the Perry case. And then in the meantime, we've got these several DOMA challenges working their way through the federal courts. And the two leading cases, as everyone knows, are the Gill case and the case brought by the state of Massachusetts. And the trial court decision in that was also August 2010. August is a big month. That case is pending before the First Circuit. And we're kind of just, everybody's in the middle of briefing that case when this very dramatic announcement came from the Department of Justice on February 23rd that it's no longer going to defend the Federal Defense of Marriage Act in any of these cases. And the Attorney General, Eric Holder, sent a letter to Congress notifying them that that the DOJ is no longer going to defend DOMA, and giving Congress the opportunity to do that if they want to. And in terms of the timing of this decision, the timing wasn't too surprising. The substance of the decision was really momentous and a really big deal. But the timing of it did make sense, because in the Gill case, the Department of Justice has been able up till now, because there's another First Circuit case that one can read as mandating that the First Circuit has already decided that rational basis applies. I don't actually read the case that way, but you can. And so the Department of Justice have been able to say up to now, look, we're not taking an independent position on what level of scrutiny should apply to laws that discriminate against gay people. This case is coming up in the First Circuit. There's already First Circuit precedent that says rational basis, so everybody's bound by that, and we'll defend the statute under this rational basis test. But then two new DOMA challenges were filed, one in New York and one in Connecticut in November. The Windsor case in New York and the Peterson case in Connecticut. And that really put a lot of pressure on the Department of Justice, as we all knew that it would, and we and many others have been telling them, including Walter Dellinger writing a very powerful op-ed, telling them, hey, you guys are about to be between a rock and a hard place, because once DOMA challenges come up in circuits where there is no binding precedent on the level of scrutiny, you are the Department of Justice of the United States of America. You have to take a principled position and tell the court what you really think about what level of scrutiny should apply to laws that single out gay people. And are you really going to get up there and tell these courts that you think anti-gay laws should be considered presumptively valid and only subject to this lowest level of review? We know you don't believe that. You know it's not constitutionally right. You're the chief constitutional officers and attorneys for our whole country. You're supposed to be defending the Constitution and telling the courts, helping the courts figure out how to tell us all what the Constitution means, and you just can't get up there and say that. And so to their credit, to their enormous credit, once those cases got filed in a circuit where there was no binding precedent on this issue, and they had this March 11th deadline coming up that they had to respond to the DOMA challenge, these 2 new DOMA challenges, that really prompted them to come out with this announcement and say, look, we're now in a place where we have to say what we think the level of scrutiny is. We think heightened scrutiny absolutely applies if you look at the relevant factors. Given that heightened scrutiny applies, there is no way we can any longer defend this statute. And so that's what has just happened. and now it's I think now everyone's trying to figure out, okay, what exactly is this going to mean in terms of the timing of all these existing cases? So the House, the Speaker of the House, Boehner, appointed this committee, a bipartisan legal advisory committee with 3 Republicans and 2 Democrats, and they voted on whether the House should spend money to hire private counsel to defend all these cases. And surprise, surprise, given the composition of the committee, they decided they would do that. So they have at least told us now that, yeah, we're going to go out and spend taxpayer money to hire private attorneys to intervene in these cases and defend the Federal Defense of Marriage Act. One little side note here, it's actually really fascinating to me that, so we now have at the federal level the same set of issues playing out as have been playing out in California with the Prop 8 challenge, where we had the governor and the attorney general in California saying, no, you know what, we're not defending Prop 8, we agree with you, it's unconstitutional. And once it got struck down by Judge Walker, they're saying we're not going to appeal. And now the question with the California Supreme Court is deciding is, well, is there anything in California law under those circumstances that authorizes the people who put this law in the first place, which is happens to be ballot initiative proponents because it's a ballot measure, that gives them the authority to override the litigation decisions of elected state officials who are supposed to conduct litigation for the state? I think the answer clearly there is no. At the federal level, though, there is a federal statute that says when the executive branch decides not to defend a law that's been passed by Congress and that's been declared to be unconstitutional by a federal district court, that actually the Attorney General has to notify Congress. So that's why Eric Holder sent the letter that he sent. There's another statute that says the Senate has the authority to step in and intervene and defend the constitutionality of the law. There's actually not a statute that says the House does, but it probably isn't going to make any difference because in practice they have actually done so a number of times in the past without any difficulties. So I'm fairly confident that's what's going to happen here again. But it's really interesting that I think what this says something very important about the historical moment that we find ourselves in. It's extraordinary, and I don't think it's ever happened in any other civil rights movement. I may be wrong about that, but I can't think of any historical precedent where public opinion has shifted so profoundly kind of in the middle of a legal struggle for equality that we have executives all over the country. Now, the Department of Justice in California, this also happened in Florida when the state of Florida decided not to appeal the decision saying that Florida's adoption statute was unconstitutional. We have all these executives sort of in the midst of litigation challenging these discriminatory statutes, saying we're not appealing these court decisions, striking them down. We absolutely agree these statutes are irrational, discriminatory, harmful, they serve no public purpose. We're not going to waste taxpayer money and put our own credibility at risk by standing up and defending something we think is indefensible. So I think that is a remarkable, really dramatic turn of events. And I think even for those of us who are litigators, I think it takes a moment for us to even kind of catch up with what has just happened and to figure out how to navigate those situations. So all we know now is that the House is going to hire private counsel and they're going to be participating in all these cases. But again, when and how long is that going to take? Right now, the briefing schedules in all of the cases have been suspended. In the Gill and OPM case, the court, it's really funny. It's worthwhile to read the orders in some of these cases because the courts are kind of like, okay, federal government, you tell us what are you doing now? Are you going to file a new brief, or what's happening? And what do you know about when the House may be planning on intervening here? And so, it's kind of fun to read those orders, but I hope that this doesn't cause too much delay, particularly in the Gill case. Would really like to see that case go forward as quickly as possible, and assuming that it doesn't, the intervention on the part of the House doesn't take too long, it's likely then that Gill will be decided and will be going up this year. And if that's the way things play out, then it's probably likely that Gill will be getting to the U.S. Supreme Court before Perry, but it's not a sure thing. Yeah.
I might have missed this. Have you mentioned the Massachusetts Attorney General's suit on DOMA?
Yeah. When I say Gill,
it seems to be the strongest.
Well, both of them, yes. Gill is the case brought by GLAAD on behalf of married couples in Massachusetts, and then the OPM case is brought by the Commonwealth of Massachusetts, representing itself, which is really powerful and another kind of breakthrough to have a state stepping in and challenging the Defense of Marriage Act on behalf of our community was really quite phenomenal. And those cases are now consolidated, so they are both being heard at exactly the same time on appeal, and they will be moving forward together. Yeah.
Shannon, first of all, thank you for your work on this. I've been watching the work and watching you on the video. In terms of the time, there's sometimes a strategy in delaying things. Whose advantage are these delays going to play into? GLAAD, and I'm talking about not just in the GLAAD case, but across the board.
Well, delay is not helping us right now. I mean, we have the momentum on our side. Having DOJ come out making this really phenomenal announcement is it's a huge development.
That was a big deal.
And I think that we should all be doing everything we can to keep that momentum going in terms of public opinion and really helping keep our community engaged and pushing on DOMA as hard as we can in as many different places as we can. I expect actually that we may see more DOMA challenges being filed in states where couples' marriages are recognized.
Do we lose anything on either a legal plane or a strategic plane? Do we lose anything if these drag on and on and on?
Sure. I mean, we're the ones suffering. It's our community who are being denied, very fundamental, basic constitutional protections. Well, I mean, we have now Judge Walker's decision from August of last year saying unequivocally that Proposition 8 violates fundamental provisions of the Constitution, but it's still in the books. And
let me narrow the question.
Okay.
I asked it wrong.
Okay.
Do the chances of repealing these laws go down if the time frame drags on? Is there anything out there strategically that is driving? Because the other side is really working very hard at delaying these things, so they must think that there's a payoff in it for them. And I'm really trying to get it that not just that people are suffering, I get that, but in terms of the ultimate result of getting them repealed.
I think time is on our side, actually. And I'm not sure the other side is trying to delay these cases. I mean, in the Perry case, it wasn't the other side that was seeking any delay. I mean, we just happened to, draw a panel with Judge Reinhardt and Judge Hawkins with two judges who we know from their prior rulings really disagree with current U.S. Supreme Court limitations on standing, and they would like to see the standing requirements broadened or opened up, and so they could have just bypassed or made their own decision about the standing issue, but they really deeply care about this issue, and so certify that question to the state Supreme Court. So that's just.
Are the DOMA supporters hoping that they'll pull different judges along the way if they can delay it long enough?
I don't think so, honestly. I really do not see any kind of intentional
Not-
strategy of delay on the other side. I think the DOJ decision was surprising to the House. I think they are moving, they move pretty quickly to make up their minds that they're going to intervene. I don't think they're going to try to hold up the show, and I tell you that the attorneys on our side are doing everything possible to make sure they don't hold up the show and really pushing the courts in these cases. They do not delay. Like, come on, let's get this show on the road. So yeah, right.
So if two judges on the Ninth Circuit on this panel don't like the way the U.S. Supreme Court restrictively deals with standing issues, and they got spanked the last time it went up there in the Arizona case, and they've sent this question off to the California Supreme Court, and you say there's nothing whatsoever in California law that's going to be useful, the assumption would be that they sent it off to the California Supreme Court looking for some kind of support for what they want to do when it goes up to the U.S. Supreme Court. You're
Sure.
suggesting they're not going to get it, so what are they thinking?
No, I don't know. I'm telling you, my view is that the answer to the question is clear. That there is nothing in California law that authorizes ballot initiative proponents.
I mean, is that an
But the
opinion
question
on-
has now been presented to the California Supreme Court, and they took it, so they're obviously taking it seriously, and they're asking for briefing on it. So, it's a serious question that is now in front of the court.
Can I just ask you if it's sort of wishful thinking on your part, or an educated wishful thinking that there's nothing in California law, or if it's just a fact?
It's I don't know if I want to characterize it as educated wishful thinking, but it's an informed opinion. I mean, there would be, I don't know where one would point to. There's no statute, there's nothing in the Constitution, so to come up with an argument on the other side, you're going to have to, I don't know what, like cobble something together. I will say, however, that it certainly puts the California Supreme Court in a very difficult political position. They're not supposed to pay attention to that, and I think they do their best not to pay attention to that. But they're now back on the political hot seat in terms of they're the ones who now have to tell the voters of California that they don't have, the ballot initiative proponents cannot step in and defend or appeal a measure. I think it's a somewhat technical issue that the public may have some difficulty understanding, so I think that, it would be helpful for us all to be helping educate the public about what's really at stake here. I mean, if you think about it, it would be disastrous policy to let private initiative proponents be able to override a decision by the governor or the AG not to appeal for a number of reasons. Because the governor and the AG, they have to. It is part of their job. They have to be looking at the whole picture. They have to look at all California state laws and think about, well, how do the legal issues in this appeal, they might undermine some other areas of state law. They have to be looking at everybody's interest in the whole state, not just the narrow interest of the people who passed this ballot initiative. And they have to take the fisc into account. If the court were to say that ballot initiative proponents have some kind of special power, that if they disagree with the Attorney General's decision not to appeal a federal court decision striking down a state law, that they can always come in and override that and appeal, you could have like an appeal with like an infinitesimal chance of succeeding, running up huge attorney fee bills on the other side and like bankrupt the state, just because this one private group of people are so, wedded to their initiative. So, I mean, the idea that the California Supreme Court would say that California law gives anybody that power is shocking. It's really distressing. It would be a disaster far beyond anything to do with gay issues, on the one hand. On the other hand, they're in a very difficult political position. It's a very heated issue, and it will require them to set all that aside and really take a sober, objective look at the law and not be swayed by potential public backlash if they say that the proponents don't have a right to appeal. So, yeah.
Yeah, I mean, if I can just add, I think that that's a good question, but isn't there sort of, from the Ninth Circuit's perspective, that this has been the discussion that the California Supreme Court has been having over the past several years? From the initial case, from the marriage case, to the way that they're going to treat the initiative proponents, to the case after, about whether or not Prop 8 is appropriate as an amendment, that the Ninth Circuit, to a certain extent, especially because of their position, Reinhardt's position on this, that basically allowing the California Supreme Court to continue this discussion about the way that initiatives are handled in California.
Yeah, no,
That it doesn't, I don't think that you necessarily can read everything into it based on their opinion, so much as the discussion that has happened in California.
Well, that's why I wanted to share with you all that context about the Arizonans for official English, to demystify what they did. I mean, the Supreme Court told them in Arizonans for official English, you should have certified that question to the Arizona Supreme Court. So it's completely unsurprising that when the same issue has now arisen in a second case, that they're like, well, we're not going to make that mistake again. They certified the question to the California Supreme Court. It's just very frustrating. I understand why they did it, but it's extremely frustrating because of the delay that it's going to cause. I mean, I find that.
Is there any chance the Ninth Circuit will grant Olson and Boyce's request to do away with that delay?
Yeah.
Well, that's the other thing that's happening.
That's
The
right.
plaintiffs, in light of this really considerable delay now, have gone back to the Ninth Circuit and said, hey, you should really lift the stay. You know, you put this on an expedited schedule, but things have gotten way slowed down. And they have renewed that request, and all the LGBT legal groups and lots of other people weighed in, including Kamala Harris, the Attorney General, also weighed in and asked the Ninth Circuit to lift the stay. Yeah, sure, there's a chance they will. They haven't ruled on it yet.
How much of a chance?
I honestly don't know. I'm not being trying to hide the ball. I just really don't know. The legal arguments for lifting the stay are extremely strong, so I'm not sure how they will justify it if they don't. Yeah.
What about any more cases that would overturn state DOMAs? Are there something going forward in the Minnesota courts, the district court or something like that?
Not in Minnesota, but there are two other cases in California. One called Dragovich, which is in front of Judge Claudia Wilkins. We've already got a positive ruling on the motion to dismiss, and that's about married couples in California who cannot get long-term care benefits, state employees who can't get long-term care benefits because of DOMA. There's the Karen Galinsky case.
What I meant by that was
Yeah.
state statutes, like the statutes that, I mean,
Yes.
similar to the Arizona case, basically. Similar to the Iowa case, that's what I meant by that.
The only case like that that's going on right now is that Minnesota case, and they actually just lost. So,
Oh.
yeah, which is, not terrible. Well, there's bad precedent in Minnesota, so they would have had to reverse a prior decision, and they were not ready to do that. So, yeah.
I'm wondering what you think of the community property tax situation in Washington and California and Nevada and one other state, and whether or not you think that that's an inroad towards the state DOMA challenge for, say, a state like Washington.
Yeah, so do people know that the IRS has said that it will require people who are in same-sex couples who are either married or in some other relationship in community property states, that the IRS is going to recognize that it's going to recognize that your property is community property, which has a very significant effect on how you have to file your state income taxes. And on the one hand, it's great because it's a step towards recognition. On the other hand, it puts some people in a really difficult situation, and it just becomes very hard for a lot of people to figure out exactly what they're supposed to be doing now with their federal taxes. And yeah, you're asking the question, is that likely to give rise to litigation possibly? And yes, like I said, I think especially now with the DOJ decision and just the heightened consciousness in our community and in the wider public about the unfairness imposed by DOMA, that we probably are going to see more people bringing cases challenging various aspects of DOMA, and I think that is a good thing as long as they're in sensible places and well put together. Yeah.
Do you think that, thank you for your work, Shannon.
You're
Do you think that given the DOJ on DOMA and the long timeline that we have with the way that the Ninth Circuit is sort of saying, hold on Prop 8, do you think that LGBT Californians should return to the ballot box to repeal Prop 8, since we don't know if the stay is going to be lifted? We don't know how long it's going to take the Ninth Circuit to rule, etc. Do you think that by that repeal Prop 8 should be placed on the 2012 ballot?
Gosh, I don't know. That's way beyond my pay grade. I think it's probably a serious conversation that we should be having across the state. You know, I don't know. It's.
What's your gut?
I really, honestly, I don't know. I really don't know. Yeah.
How about more of a legal question then? Let's assume the Ninth Circuit upholds Walker and the bad guys appeal it to the U.S. Supreme Court. There are at least maybe 3 different ways that the U.S. Supreme Court could rule in our favor.
Yeah.
But some of them would be much more limited, have much more limited impact than others.
Yeah.
I think that would be like really interesting to hear about from you.
Yeah. There are 3 ways. One, they could rule that the proponents do not have standing, and then that's the end of it, and Judge Walker's decision is final, and there's no more Prop 8 in California. They could rule very, very broadly and say that Prop 8 is invalid because same-sex couples have a fundamental right to marry, and denying them that right violates equal protection. That would mean that every state in the country has to allow same-sex couples to marry. Or they could do an intermediate ruling that was looking just at the really unprecedented circumstances in California. What happened in California has never happened anywhere else before. There is a history in this country of, including in California, of voters rolling back established anti-discrimination protections around race in the area, particularly of housing. That was a really controversial area at one time. The laws prohibiting race discrimination in housing were very sensitive, and there were all these horrible, voter initiatives all over the country to try to roll back those laws. That actually happened in California. That was challenged under the federal constitution. It went up to the U.S. Supreme Court, and the U.S. Supreme Court said you can't do that. And the court said there was something sort of uniquely invidious about first extending a recognition of equality and then taking it back. That has like a uniquely damaging effect, and so there's some interesting precedent there. But we've never had something happen like what happened in California, where first you have a state Supreme Court decision saying that this group of people gets the highest level of constitutional protection. They're fully entitled to participate in this fundamental right, and then have the voters come along and take that back. But they didn't take it back fully. The voters could have said, you know what, we disagree with current California policy that says that gay people should be treated equally, and we're changing that. We think gay people are different. We don't think that their relationship should have legal protections, and we're changing our mind on that. But they didn't. They said, we're not changing anything about California law. We don't want to take any rights away from anybody. We just want to keep marriage just for straight people. And so then we had the California Supreme Court construing Prop 8 in the unsuccessful state court challenge. The court said what Proposition 8 literally did was create an exception to the requirement of equal protection. It didn't change anything about the underlying policy in California that gay people are in principle. California recognizes gay people are in principle entitled to be treated with full equality, but we don't want to. We want to create an exception for the status of marriage because we would like to keep that for ourselves. We, the heterosexual majority, would like to keep that for ourselves. So that construction, that interpretation of Prop 8 is binding on all the federal courts. We now have the California Supreme Court having told us exactly what Prop 8 means and exactly what it does. And they said it literally creates an exception to the requirement of equal protection. So under the U.S. Supreme Court case law about these old cases about rolling back housing discrimination protections, and under Romer, where the court said that there's certain kinds of, Romer was the 1996 case that struck down the Colorado amendment that said that the state could never pass anti-discrimination protections for gay people. And the court said in that case, there's certain kinds, even apart from, never mind what level of scrutiny this particular law should get, there's certain kinds of legislation that are so overtly anti-egalitarian on their face that you just can't do it. If it's certain things that violate the fundamental premise of equal protection so blatantly that our constitutional tradition does not permit them. If the court found that the amendment in Romer was in that category, I think it's very likely they're gonna find that Prop 8 is in that category, because Prop 8 literally creates an exception equal requirement.
Let me just
equal
say one
protection.
word about
Yeah.
that, and that's Cincinnati.
Yep.
So
Yeah.
I wouldn't take that one as a bank either.
Right, and they wouldn't review, the US Supreme Court declined to review. Yeah, there was a case after Roma that seemed to be exactly the same situation, and it was upheld by,
It was exactly the same
Yeah.
language, and as soon as Romer was filed, they took that up, and the court said, no, we don't wanna hear that. So for some reason, Cincinnati's law was different than Colorado's law. Nobody's real sure what that means, but I don't know that I would take that logic to the bank until we see it.
we'll see, yeah. But those are the three broad possibilities, but before, and I think we're running out of time, and the one thing Matt wanted me to get in, so before I fail to do that altogether, I just did want to alert people to the fact, there's another case that may be the first case, long before Perry or Gill, that gets to the US Supreme Court about our community, but about a different issue. It's very important, though, that we're starting to see cases come up all over the country where the issue is whether one state has to recognize adoption decrees from other states, adoption decrees granted to same-sex couples. There's very clear US Supreme Court case law that states have to recognize judgments from other states. So if you get a court order from one state, every other state has to recognize that, even if the underlying basis of that court order is totally repugnant to the public policy of the second state. But we're having to fight this out. We've got states like Oklahoma that said we're not recognizing adoption decrees from same-sex couples. Lambda brought a case challenging that Oklahoma statute, and it went up all the way up to the 10th Circuit, and they won. That was wonderful, and that case is over. There's no further appeal on that. But there's a case right now in the 5th Circuit where it's a challenge to a Louisiana law where Louisiana will actually not recognize adoptions granted to unmarried couples, including same-sex couples. So that's Lambda challenged that. They won at the federal district court level. They won in the original 5th Circuit panel opinion, but then the entire 5th Circuit said, oh, we want to hear this issue. So the 5th Circuit is a very conservative court. That just was briefed and argued, so we're waiting for the entire 5th Circuit now to issue its decision. Yep.
Do you have the name of the case?
Adair, A-D-A-R. And I think either way that comes out, that case may very well go all the way up to the U.S. Supreme Court. Yeah.
Does Romer cover only voter-approved initiatives, or could it also cover what happens conceivably in Montana, or what's going on right now there?
What is going on?
The state legislature just voted to invalidate a local LGBT rights law.
Oh, really?
In
That's
Billings,
terrible.
yeah.
No, I think the logic in Romer would apply to either a legislature or
state
or
initiative.
voter initiatives. Absolutely, yeah. I hadn't heard about that. That's terrible. Anyway, so just wanted to alert you all that this this 5th Circuit case is out there. It's an extremely important issue. I mean, it'll be unprecedented. There's very few things in the law that are black and white, but this principle that states have to recognize judgments from other states, comes as close to a black and white rule as anything we have, particularly in constitutional law. So for even a court of appeal like that to undermine that principle would be shocking and unprecedented, and it's so important, and I think it is likely that the U.S. Supreme Court will take that issue up. I actually feel very confident that we would ultimately prevail on this in the U.S. Supreme Court, but it's a really important issue. It affects tons of people in our community who have adoption decrees or parentage judgments and moving from one state to another, and it's a really important.
What's the right wing, how is the right wing going to try to be on the side of Louisiana? What's their messaging going to be, do you think?
They've tried to come up with these arguments, which they just manufactured out of thin air, and they don't make any sense, that somehow adoption decrees are different than other judgments.
Just like marriage is different, right?
Well, marriage actually is different. I should explain that marriage is not a judgment. So marriage is, the full faith and credit clause applies to judgments, records, and acts. And the only, this ironclad law that one state has to recognize another state's judgments only applies to judgments. It does not apply to records and acts. When it comes to records and acts, there's a public policy exception. And if another state's record or act violates your state's public policy, you don't have to recognize it. So that's why marriage is actually, one state doesn't have to recognize another state's marriage, but just based on full faith and credit, because there's a very long-standing public policy exception. But judgments, like adoption and parentage decrees, yes, those must be respected state to state. So that's what they try to say. Oh, well, adoption decrees, they're somehow different, or they come up with these very convoluted arguments that, well, we're not denying full faith and credit. It's just we're just enforcing it based on our own state's laws, which really doesn't make any sense either. So, yeah, they're not. They don't make the argument yet, although I won't be surprised if they do at the U.S. Supreme Court level, that the court should create a new exception to full faith and credit. They haven't argued that yet, but I wouldn't be surprised if they do.
Shannon, we have a few more minutes for you to take questions. I just want to apologize. I got to do a technology transition.
problem,
So
no problem.
try to ignore me.
Yeah.
Sometimes it feels like everything is in the lawyer's hands, and we're all just kind of watching out here. I think Hurricane, they were trying to tell stories through the court of misery. What can everyone do besides just observing cases?
Yeah, Adam, thank you for asking that, because I think the worst thing that can happen to our movement is for people to think that everything is in the lawyer's hands. I mean, I hope that, if nothing else taught us that lesson, that the history of California in the last few years would have taught us that lesson, that, it's always a huge mistake if we think that one court case or some small group of lawyers or even a big group of lawyers is going to be our saviors. No, we've got to, the only way you get secure, lasting change is to change public opinion along with winning court victories. And winning court victories depends a lot on changing public opinion. I actually think one of the things that the Perry team has done so phenomenally well is pay attention to the public education, community education side of that case, and they've really worked so hard, while they're litigating the case, to also, keep the community informed about what's happening, to get more and more public officials, including many Republicans, to come out in favor of marriage equality. I mean, that, because of the way they've approached that case, which is also the way that, the LGBT legal groups try to approach our cases, is you really bring public opinion along at the same time. But we've got to have community engagement in that. And I know that people have heard this message over and over again about share your stories. And maybe we, the advocates, need to reframe, sharpen our message to the community, because I don't know what it's going to take to push people to that next step to really, we need a massive mobilization of every LGBT person, for sure in California, but in the whole country, really willing to push the envelope and really willing to be uncomfortable and take some personal heat and, do things that are not easy to do, which is push these conversations at work, push these conversations with your family. And we need to stop colluding in our own invisibility. Anytime there's an official document, or even you're checking into a hotel or whatever, where you have to identify your marital status, I really wish people would, regardless of what the law is in your state about whether your marriage is recognized, don't let that stop you. Don't go along with that. Don't cooperate with that. Just be honest about what your marital status is, and don't disavow your spouse. Don't disavow what you believe to be the case. If you're legally married, or even if you want to be married, I think people should claim that and assert that. And if we would all stop cooperating with these discriminatory laws that try to make us invisible, I think that could have a huge effect, actually. So whatever it takes to sort of have this awakening of consciousness in our community, and I think the kind of stuff that you've been doing with the Courage Campaign is a great example of that. Like the story collecting that you all have been doing is phenomenally powerful.
Jumping back to Prop 8 a little bit, you had mentioned that we have all these delays, and also that a couple different people had mentioned the really rapidly changing public opinion. I know in general the Supreme Court tends not to like to be a whole number of steps ahead of the American people. Is there a possibility that this delay will buy our movement another couple years of getting public opinion further above that, you know, majority 52% mark that we're at now for marriage equality, which could have an impact on the ruling? Is that
Yes, but only if we make something of this 2 years. I mean, only if this, only,
I mean, I guess if we get
Yeah.
our asses and do something.
exactly, no. I mean, it really is gonna depend on whether the community continues to be engaged, and we need to amp it up. I mean, if we need more than there needs to be more engagement than what we have right now. Yeah.
One quick thing, and then I have a question. One quick thing is that a lot of people think this time delay will help get Kennedy more and more over to our side to go 5-4. But my question is, I get really frustrated when I see millions upon millions of dollars, not in California, but like in states that we just have absolutely no shot. Now, I'm not from those states. I look at Jeremy from Indiana. You know, you can't just sit there and you know, take this unbelievable amount of bashing, but I'm so frustrated at the money. Like, what do you guys think of that? Like, we should be spending all this money in all these states fighting these? We should tone it back? Like, I'm just wondering if you have a thought.
Yes, I completely think we should be fighting back, and we should be, you know, it takes money to do that, but the focus on marriage in our community in the past must have been, you know, really since the Hawaii decision in '93, and it just keeps building and building, has brought in enormous new sums of money into our movement. It's gone both for marriage and for all kinds of other things, and it's got so many more people engaged than were otherwise engaged, and has exponentially increased the overall pot of money that's available, and just the number of people in our community who are paying attention, who care, who are engaged. And so I think, you know, for those of us who care about issues beyond just marriage, which I, you know, absolutely put myself in that camp, we need to make the most of this opportunity. And now that we have so many people in our community paying attention and engaged, let's use that and get people engaged in other issues as well, like the LGBT youth issues and the stuff you're about to hear from Caitlin, which I think is seriously the most important. The messages you're about to hear from Caitlin, in my opinion, are the most important messages that we could all be sharing with everybody else in our community and with public officials and state legislators. So I'm glad you're about to talk to us. But I think it's